Welcome to Evolve Academy. If you're a content creator, entrepreneur, or online business owner, understanding contracts is one of the most important skills you can develop. Whether you're launching a new product, collaborating with brands, or just trying to protect your creative work, contracts play a crucial role in making sure everything runs smoothly. In this tutorial series, Understanding Contracts, we're going to break down the basics of contracts in a way that's easy to understand and directly relevant to your business. We'll dive into the fundamentals by answering the key question. Lesson 1. What is a contract? During Lesson 2, we'll explore why contracts are so important in the world of business and content creation. Next, during Lesson 3, we'll look at the difference between written and oral agreements and the advantages of having a written agreement. Finally, during Lesson 4, we shall discuss the different types of contracts you might come across, and the different industries where these agreements are typically used. These agreements also cover some of the standard contracts you're likely to encounter as a content creator or online business owner, like service agreements and licensing deals. By the end of this series, you'll have a solid understanding of how contracts work and how to use them to protect yourself and your business. So, if you're ready to level up your knowledge and ensure your business is legally sound, let's jump right in.
Definition and purpose of contracts. Lesson 1. What is a contract? A contract can be defined as a legally binding promise, oral or in writing, by one person to fulfill an obligation to another person in return for consideration. Contracts play a crucial role in any commercial arrangement. The contract cements the relationship between the parties to the agreement. A contract is a legally binding agreement between two or more parties that outlines their rights, responsibilities, and obligations. It is essentially a promise or set of promises that the law will enforce. Contracts can be written, oral, or implied by the actions of the parties involved. But written contracts are generally preferred because they provide clear evidence of the agreement. For a contract to be valid, the following elements are present. Offer. One party proposes specific terms to the other party. Acceptance. The other party agrees to those terms. Consideration. Something of value is exchanged, such as money, services, or goods. Under English contract law, the elements of an intention to create legal relations and capacity may also exist. Under U.S. contract law, the doctrine of mutual intent applies, which means both parties intend to enter into a legally binding agreement. If any of the above elements are missing, the contract may be considered invalid or unenforceable by the courts. Lesson 2. The role of contracts in business and content creation. Why have a contract? Contracts play a crucial role in both business and content creation by establishing clear expectations and protecting the interests of all parties involved. In business, clarity. Contracts outline the specific terms of a deal, including deliverables, timelines, payment, and special requests such as confidentiality. This helps prevent misunderstandings between the parties to the agreement. Protection. Contracts protect the parties by legally enforcing the agreed terms. If one party fails to meet their obligations, the other can seek remedies through legal channels, such as a claim for damages. Professionalism. Using contracts demonstrates professionalism and helps build trust in business relationships, and instills confidence in the parties that the agreement shall be honored. In content creation. Ownership. Contracts determine who owns the rights to the created content, such as articles, videos, or designs. This is vital for protecting intellectual property, such as copyright protection. Usage rights. They specify how the content can be used, distributed, or modified by others. This prevents unauthorized use or alterations. Compensation. Contracts ensure that creators are fairly compensated for their work, whether through upfront payments, royalties, or other arrangements. In both contexts, contracts are essential tools for managing expectations, ensuring fairness, and minimizing risks. Lesson 3. Types of contracts. Let's take a look at the differences between written and oral contracts. Under English contract law, both oral and written agreements are valid and legally binding. So, why have a written agreement as opposed to an agreement where the parties reach an agreement during a conversation? If a disagreement does occur, relying on memory alone for what was agreed between the parties is unreliable and gives rise to uncertainty. One person may hold a different opinion to the other about the rights and obligations under the agreement. Oral agreements therefore do not provide clear rights and obligations. The parties may interpret the words exchanged in a different way. For the same reasons, it is difficult to prove a breach of contract where the contract is verbal rather than written. A judge would have to determine if a breach had occurred based on one person's word against the other. A written agreement provides clarity and ensures the parties understand what their rights and obligations are under the contract. This means it is easier to judge whether or not there has been a breach of contract, thereby allowing a party to claim damages.